Now, John, have you had a chance to speak with Chris Barber about his 18-month conditional sentence and 100 hours of community service? Does he feel vindicated? A huge sigh of relief? I mean, after all, the Crown was seeking an 8-year prison sentence for your client.
I've not had a chance to talk with Chris yet, but I was very happy that he was not locked up in jail for any amount of time. So, this conditional sentence, it depends what you compare it to. If you compare it to, normal freedom, it's definitely a penalty, a punishment. And you cannot just freely leave your house and connect with a buddy over a coffee or over a beer. You're only allowed to leave your house for employment or church attendance, for medical appointments, for very narrow, specific reasons. And other than that, you have to be at home. You're under house arrest. So compared to, normal life, perfect freedom, it's definitely very negative. However, when you compare it to being locked up in jail, it is a lot better than that.
Now, Justice Perkins McVeigh said that Mr. Barber came with the noblest of intent. It did not advocate for violence. Now, what about those who lived through the Freedom Convoy in Ottawa, John, and they say otherwise?
Well, we've got a double standard in Canada. The city of Ottawa recently quashed fines that were given to pro-Palestine protesters who were breaking noise bylaws with their megaphones. And yet all this complaining about the horn honking, which really was only the first few days that the horns were honked a lot, because the truckers also wanted a good night's sleep, and they actually consented quite early after their arrival in Ottawa to a court order. But you see a double standard there. You see a double standard when protesters against residential schools in Winnipeg tore down and vandalized the statue of Queen Victoria. Obviously criminal conduct committed in broad daylight with police watching. Nobody's charged. So the problem we have in Canada is a double standard for prosecutions. If you are protesting against lockdowns, vaccine passports, then they throw the book at you. But if you are protesting against racism or residential schools or Israel, then you get a pass.
But the judge also emphasized the peaceful nature of the convoy, describing it as a nonviolent protest. But John, if that's the case, why were so many arrests made and bank accounts frozen?
It was terrible misconduct on the part of the federal government under Trudeau. There was no national emergency. At the time when they declared a national emergency, the border protests in Windsor, Ontario and Coutts, Alberta had both been resolved. So they were down to one local protest in Ottawa only. And thankfully, civil liberties groups, including the Justice Centre, were active in getting this court ruling to the effect that the federal government did act illegally when freezing bank accounts. So we do have a declaration from the federal court, although the federal government has appealed that judgment. So we're now waiting on the Court of Appeal ruling.
So, John, what message, bottom line, do you think this conditional sentence sends to Canadians?
It's a mixed message. I mean, I think that if Tamara Lich and Chris Barber, if they were fairly convicted, and if it's a valid conviction for the criminal code violation of mischief, then there ought to have been, and there should be, prosecutions against all kinds of people for doing much, much worse. So, my problem is really with the double standard, which undermines the rule of law and diminishes respect for law when you have Crown prosecutors and politicians applying different standards for different people based on their political beliefs. The law should treat everybody equally. And so it shouldn't matter what cause you're protesting for or against, but there should be an equal standard applied in terms of criminal misconduct.
John Carpay, president of the Justice Centre for Constitutional Freedoms, thanks so much for joining me today from Calgary.
Thanks for having me on your show.